Hi, good afternoon, everyone. My name is Kayla Sayas-Ruiz. I'm the program director for the Sunshine State Digital Network. I'd like to welcome you all today to our webinar on ADA Title II for cultural heritage websites. As we all know, that deadline with the new rules is coming up. So we wanted to give you all some practical guidelines for complying with those new guidelines. Today's session is being recorded, so you will get a copy of the slides as well as a copy of the recording, and it will be available on our YouTube channel afterwards. Today's meeting is also being transcribed, so if you would like to see captions, just click on the CC button that's located at the bottom of your Zoom window. Please excuse any errors in transcription as these are automated captions. And we will be taking questions in the chat, so you feel free to enter your questions at any point during the presentation in the chat box, but the questions will be answered at the end of today's presentation. So without further ado, I will pass it to our presenter today, Brian Brown.
Thanks, Kayla. Hi, everybody. Thank you for coming to the presentation today, ADA Title II for Cultural Heritage Websites. I've been a little bit under the weather lately, so I apologize if my voice sounds a little bit hard to understand or stuffy. Trying to deal with it the best that I can, but it's spring and allergy season, so I'm sure you all know what that's like. Um, During this presentation, we're going to be going over the answers to some questions that I think are the most basic questions that you should understand in terms of ADA Title II and how it applies to your institution. I'll talk a little bit about FSU Library's journey with reaching ADA Title II compliance. And then I'll finish off with some tips that, in my opinion, are the most important things for you to keep in mind as you are working towards compliance at your institution. So I'll start off by introducing myself. I'm Brian J. Brown. I'm a repository developer at Florida State University Libraries, and I don't identify as an accessibility expert per se, but I've always seen the value in accessibility and see it as a core part of just the process of making content for the web. If you're making content for the web, but you're not making it accessible, then you're making low quality content for the web. And not everybody understands the importance of accessibility. Not everybody is competent with what the exact things that you need to do in order to make content accessible. But I do believe that that's the responsibility of every content creator is to make sure that you understand accessibility and that you're applying it and practicing it in your work. Part of my work with accessibility has been performing accessibility audits and remediation throughout several different web services for different reasons in my time at FSU Libraries. Um, we've even published journal articles on our remediation processes for our repository. And also, like many of you, I'm assuming that you're coming to this presentation because you are also under organizational pressure to ensure that all your web services are ADA Title II compliant. But the most important thing for you to know about me is that I am not a lawyer and this is not legal advice. If you have attended the copious ADA Title II presentations that have been coming out end of last year and beginning of this year, this legal disclaimer is pretty common, and it's because this ADA Title II is a law, and as a law, it is pretty hard to read and subject to interpretation, which I do not have the legal experience to create an objective interpretation. So I am only telling you what I think that the law says and how I think you can comply with it. But if you find yourself in legal jeopardy and you tell them that Brian said it was okay to do this, that will not be legally adequate. So, We'll start with talking about what ADA Title II is. ADA, when people talk about ADA Title II, in the context of libraries or cultural heritage institutions, lately, they are talking about not just ADA Title II, but a very specific part of ADA Title II. They're talking about the Americans with Disabilities Act, Title II regulations, Part 35, non-discrimination on the basis of disability in state and local government services. And that has to do with lots and lots and lots of ways that you have to make stuff accessible. But it is Subpart H, web and mobile accessibility, that actually states this requirement for public content from public entities needing to be digitally accessible by April 24th, 2026, a date which I'm sure you all have heard many, many times by now. There is kind of a, I don't know, I don't want to say a loophole or an exemption, but there's a caveat, I guess, to that, where some places don't need to be ADA Title II compliant until 2027 if they have a population of less than 50,000 people. I am not entirely sure what that 50,000 refers to. So, in my opinion, if you haven't been told by someone else that 2027 is your year, just assume that April 24th, 2026 is your year and shoot for that. Do the best that you can. Um, when it comes to public content and public entities, we'll kind of get into what that means a little bit later. But public content is really anything that your organization puts out that is not behind a password or anything like that. It is information that is accessible, well, is can be accessed on the internet. It's not necessarily accessible because that's what we're talking about here. Social media is public content. Your social media will need to be accessible. Uh, Documents in a repository are public content. Are they subject to ADA Title II? We'll get into that later, but they are definitely public content. And the accessibility standard that you need to reach for all of this public content, if you are a public entity, by April 24th, 2026, is the W3C WCAG 2.1 A and double A levels, which that's a mouthful. It's complicated. We've got a whole slide on exactly what that means. But before we get into how accessible your public content needs to be, let's talk about what public content is an exception. Uh, in Part 35.201, there are a few exceptions that is content that does not need to be made WCAG 2.1 AA compliant in order to be ADA Title II compliant. Uh, the biggest section of this is pre-existing content, which is content created before the deadline of April 24th, 2026. Uh, you cannot update this content after April 24th, 2026, lest it stop being pre-existing content, and then now it has to be made, all the way accessible. You should also have some way of marking this content as archival so that no one mistakes it for new active documentation or content. There are a variety of ways to do this, and I haven't really heard a whole lot of best practices for how you mark things as archived, other than maybe saying something on the page saying, like, this is archived content, it will not be updated. It's here for what's the word I'm looking for posterity purposes. Uh, there's also an exception for pre-existing conventional electronic documents. Now, what are conventional electronic documents? Uh, I'm taking that to mean like PDFs and forms and maybe even Word documents, stuff like that. Stuff, and by pre-existing, it's stuff that was created before April 24th, 2026. There is a big caveat to this that if this pre-existing conventional electronic document uh, is required for interacting with your organization, like if you've got a form fillable PDF that people need to use in order to register for an event or to apply for your school or to get access to your archival reading room or something like that, then that pre-existing conventional electronic document is no longer covered by the exception because people have to use it in order to get your services. Therefore, those documents jump to the top of the list in terms of priority. Those are things that must be made accessible as soon as possible. Pre-existing social media posts. That one doesn't require a lot of explanation other than to say that by them saying that pre-existing social media posts is an exception, that really solidifies the sometimes controversial point of view, I guess, that social media posts after the deadline must be accessible. Uh, I don't see any other way of reading it. If pre-existing social media posts were an exception, post-existing social media posts are not. And as I mentioned earlier, password protected content, if you need a password to get to it, it is automatically not public. So that means that any admin screens in your applications that you use to manage this content to the public, that's kind of off the table. It would still be nice if it was accessible just in case you have any employees that might have issues interacting with it, but that's more of a moral or employment question versus a legal compliance question. The password means that it is automatically accepted according to ADA Title II. Now, while this next little stanza here does not occur in the 35.201 exceptions category, it's part of the main rule in subpart H. It does lay out kind of the mechanics for how exceptions might work. Unless the public entity can demonstrate that compliance with this section would result in a fundamental alteration in the nature of a service, program, or activity, or in undue financial administrative burdens. That means that there are situations where new content might not be able to be made accessible because it costs too much, because you don't have the human resources, or because it would fundamentally change the way that the service works. The fundamental alteration part leads to significant disagreement in the community about whether documents in a repository are inherently archival pre-existing content that cannot be updated, but are obviously archived because they're in the repository and therefore don't need to be made accessible for ADA Title II. Or I've also heard the argument that if you take a document that an archive received and put it in your digital library, and then you go in and you start making changes to it, you are altering the archival record. You are fundamentally altering the nature of the service, which is to show the documents as they received them. Uh, and as I said before, I'm not a lawyer. I'm also not an archivist, so I can't tell you the answer to this. I can only tell you that reasonable people disagree, and I don't have a for sure answer, but my good enough answer is try your best with the low-hanging fruit of maybe the worst, most inaccessible parts of your archive. Talk with your archivist to see if that would be stepping on anyone's toes to change those records, and just try to work with the people around you to find the best solution for you to move forward. But it's totally likely that if you have a giant repository, that bringing all of its contents up to ADA Title II or up to WCAG 2.1 AA standards is going to be undue financial or administrative burdens. And if you find yourself in these situations, the key word to remember here is unless the public entity can demonstrate that compliance with this section would result. Demonstrate is doing a lot of heavy lifting here. In order for you to demonstrate it, you must be able to document what the financial or administrative burdens would be in order to argue that they are or are not undue. Uh, Same thing with the fundamental alteration in the nature of a service. You need to demonstrate the nature of the service and what the fundamental alteration would be in order to show that it's not in the ballpark of things that can happen. Um, Defensive documentation is going to be one of the themes that we return to in this presentation a couple of times. So I really want you to drill that into your heads that that's an important thing to do, that you should be keeping documentation on all of this stuff as you go, because that's going to be part of your legal defense if you get sued, which is the thing that you're trying to avoid by reaching towards ADA Title II compliance. So, we talked about the W3C WCAG 2.1A and AA standards. What do those mean? Well, the W3C part of it is the World Wide Web Consortium, and they are the governing body that determines web standards like HTML5 and CSS, and a lot of the standards that make the web possible and interoperable. They're a very important group, and they also came out with the Web Content Accessibility Guidelines. There are several versions of these web content accessibility guidelines, sometimes abbreviated to, and pronounced as WCAG. And 2.1 is not the newest. I think there's a 2.2, but ADA Title II specifically points to 2.1. And what the Web Content Accessibility Guidelines are is, in their own words, a wide range of recommendations for making web content more accessible. And when they say web content, they're not just talking about web pages. This applies to all digital content on the web, whether it's web pages or PDFs or images or media or whatever. Uh, all of those pieces of digital content have their own issues when certain people try to interact with them that may or may not have the same abilities that you do. So, all of them have recommendations from the W3C in order to make interacting with those parts of digital content more inclusive for everyone. And they have all of these success criteria for these recommendations of what the problem is and what you can do to mitigate that problem. And you can reach levels A or double A, where A is low compliance and double A is medium in terms of these levels of conformance. Like, how good of a job are you doing with your PDF or your image or whatever? And I will point out that there actually is sometimes, not always, but with a lot of things, there's a triple A level that is the highest, but it's very difficult to achieve, and legally, it's not required. So it's not something that you have to worry about, but it is a good thing to shoot for, in theory. Um, The success criteria that the WCAG defines are so well defined that they can be used as a rubric for scoring the accessibility of any given website. You can evaluate each individual page of a website, find all of its issues, kind of put them together into a big report, and then come up with a score, usually 0 through 100 on how accessible your website is generally, or how well you're reaching with a specific level of compliance like WCAG 2.1 AA. So, because WCAG is so well defined, a lot of accessibility checking tools, which I'll talk about more later, use this as a target for evaluating your website and telling you how close you're getting to the target. So, having heard all of this, you might be asking yourself, I understand ADA Title II. I understand that I need to make my content accessible. I understand what content might be public, but am I an employee of a public entity? ADA Title II defines public entities as primarily state and local governments, but also their constituent parts, their departments and agencies, and also any organizations that are funded by these state and local governments or their departments and agencies. And they don't have to be fully funded by these state and local governments. Even receiving partial funding from state and local governments, that also makes you a quasi-public entity. Uh, so, if you are receiving any amount of taxpayer money, that is probably why, or if you're receiving any amount of state funding, I should say, that probably makes you a public entity legally and subject to ADA Title II. And if you are a public entity, any public facing information, resources, or web services that you're applying are also subject to ADA Title II. And we could spend a lot of time splitting hairs about whether you are or aren't a public entity, or whether your content is or is not public. But a good rule of thumb with this stuff is that it's better to be cautious about what this applies to and kind of be conservative in your judgment. Because if you decide that you aren't a public entity and you're wrong, the consequence is lawsuits. If you decide that you are a public entity and then you're wrong, the only bad thing that happened is that you spent some time making your stuff more accessible, and that's not a bad thing. So, err on the side of caution, I would say, when determining whether or not you feel like you need to comply with ADA Title II. When it comes to working towards compliance, I think the first step is to determine who is leading. Because if someone else is leading the charge on this, and then you decide you're also going to lead your own separate charge, then you all aren't working together, and it's not going to be as impactful as it could be. Uh, in my situation, we have campus IT. We have a group called ITS, Information Technology Services, on campus that they manage a lot of the web stuff and the technology stuff that makes the campus run. As such, they are now very preoccupied with ADA Title II compliance, and they've got a group of stakeholders that are working on it and making sure that everyone is working towards compliance and giving reports and stuff like that. You may not be in an organization that has a central IT group that works on this stuff. Maybe you're lucky enough to have a dedicated accessibility person on your staff. And if that's the case, that's going to be an obvious point person to run with this stuff because accessibility is hard. It's a difficult, complicated thing to deal with, especially if you don't have any experience with it. So having someone who does is really going to give you a leg up. But just like with campus IT, not everyone has the privilege of having a dedicated accessibility person. And if that's the case, if you don't have other IT people, if you don't have other accessibility people, you might be leading by default because you are the person who best understands what the needs are. And you can kind of look at that in two ways. One is that it is going to be a lot of work, but on the other hand, it is a great opportunity for you to learn about accessibility and be the person who steps in and does something really important and really necessary for your organization. So it's not all bad. You could be the accessibility hero that your organization has been waiting for. Once you have determined who is leading the charge on this stuff, the next step is for you to identify your relevant web content. Not identifying all of the web content because there might be some web content that your organization is producing, but it might be better for you to have someone else lead the charge on that one. So identify all the stuff that needs remediation and divide it up, determine who's doing what. And then once you have that audit of all the content, all the services, all the documents, all the stuff that your organization has on the web, that's when you got to start analyzing it to determine how many problems it has, how much work it's going to take to bring it into compliance, but also how important is it? Uh, like I mentioned earlier, the conventional electronic documents that you might need to fill out in order to register for classes, that might have less accessibility issues with it with another website, but it is a higher priority because it is a document people need to use. So it's probably going to get you into more legal jeopardy if that thing that people have to use is not accessible. So once you have determined what all the problems are, the backlog of work that needs to be done, and you've prioritized it, what do you do next? How do you go about actually fixing it? Well, if you have the skills and the administrative privileges to fix these problems yourself, that is the obvious answer. But if you have the privilege of having developers on staff or other IT people that you can kind of share the load with, that's also a great way to do it. Uh, Wrangling volunteers is another popular way to handle some of this stuff. Here at FSU, we have, once we created the backlog of all the stuff that needs to be done, uh, especially when it comes to stuff that's not super technical, like going into certain pages and fixing dead links or something like that. That's something that you can find a volunteer to do. That person doesn't need to be super technically or accessibility savvy in order to do that. And if you are paying vendors to host content for you, uh, especially if the problem is not with the content, but with the platform itself, you can have the vendors fix it for you, and then you don't even have to do anything. That's what you pay them for. So if you cannot reach compliance by April 24th, 2026, uh, they're not going to roll up in a van and take you to jail on April 25th. You are not going to be the person that is sued. But after April 24th, 2026, your organization is open to lawsuits. Uh, if they have any content that does not meet WCAG 2.1 AA compliance. Will people actually sue you? Uh, Remains to be seen. I feel like the people that I have met that have brought up accessibility issues with our website have usually been pretty chill. They give us feedback about a problem that they encountered because they want us to fix the website. They want us to make it better so that other people don't have those problems. And we are very thankful to them for bringing those issues to our attention and letting us understand where our faults lie there. It has not been my experience that people encounter something that is not accessible and they jump straight to lawsuits. However, it could be that those aren't the people that are filing the lawsuits. If people smell money, they might go after a cash grab of just, in the same way that people have scripts that automatically detect whenever a domain has lapsed in payment so that they can automatically grab it and sit on it and make you pay double, triple, quadruple, whatever it's worth in order to get it back. People might be doing the same thing with ADA Title II lawsuits. They might be running accessibility checks on public sites and trying to sue on April 25th in order to extract some money from you. I don't know if that will happen, but it's a possibility that I've heard people talk about, and it's something to be aware of because there are bad faith actors in the community that would do something like that. And in my opinion, the best defense against that is, like I said earlier, make an effort and document that effort. Uh, if you go to court over inaccessible content and you're able to show that you understand the problem and that you're working towards fixing it and that you have a trajectory that at least takes you towards accessibility, even if you're not there yet, you're probably going to fare a lot better than someone who just shows up and says, well, what is accessibility? I've never heard of this before. Not my problem. That's going to show bad faith in the court, and you're not going to do as well. The last thing that I'll mention is that accessibility doesn't stop on April 25th, 2026. If you haven't made your way through all your backlog of changes to be made on your website, don't just stop because April 25th happened. Keep going, even after the deadline. Don't give up. Try to make your site, better late than never. And also keep track because even if you are 100% WCAG 2.1 AA compliant on April 24th, and then on April 25th, someone from your organization adds a new web page that has a bunch of accessibility no-nos in it, then your score is going to jump down and you're now open to lawsuits again. So it's not just getting ready for this one date, it's getting ready for this date and then establishing protocols that will ensure that you are continually reviewing so that you can continually stay in compliance even after the deadline. I'm going to pause for just a second to get a drink of water. All right. So I will tell you a little bit about FSU Library's journey towards compliance now. Starting in 2024, when the ADA Title II Part 35 was released, myself and some other members of my team read through that documentation, got a pretty good early understanding of what it was asking for, and we began documenting all the websites and all the content that we'll need to review, all the stuff that we're in charge of that's put out by our organization, and just making an index of it. And then for each of those websites, all of that content, what stakeholders are involved, who needed to be engaged with it. It could be that we're aware of a page or a website that has accessibility issues, but if we're not typically the people that maintain that website, our job might be to turn over a list of required fixes to some other person for them to actually do the work or work with them to help them reach accessibility. And it's not just websites and content, it's services that you're supplying to the public and the relative priority of the work to be done. Certain websites are more used than others, and those more used websites going to have more eyes on them, and therefore a higher risk of lawsuits if there's inaccessible content on them. So, for instance, your main organizational website, for us, it's fsu.lib.edu or lib.fsu.edu. How am I gonna mess up the URL of the website I maintain? I don't know. Uh, so, we also explored a lot of accessibility tools that could help us work towards compliance. We didn't end up using all of them, but we at least got to know quite a few of them and what the relative strengths and weaknesses were and how they might be part of our overall compliance strategy. And we also spent some time seeing who else on campus was aware of and working towards ADA Title II compliance. And the short answer in 2024 really was no one. No one else that we could find on campus was aware of the ADA Title II stuff. It was just folks within the library. Um, in 2025, more people became aware of ADA Title II compliance, and we made our way through our strategy a little bit farther. We ended up settling on Site Improve as our primary accessibility tool because it has a lot of features that made it very useful to us. It is not a free tool, it's a paid tool, but it is a tool that our campus ITS already pays for a site license for. And I think it's kind of expensive, but you get what you pay for. Like it can do accessibility checks on entire websites as opposed to just pages, and organize all of those issues into reports so that you can look through patterns of issues. Like, oh, my computer went to sleep. All right. Why did that happen? Okay. Can everyone still hear me?
Yes.
Okay, good. I want to make sure I didn't like lose internet or something weird. Okay, so the last thing I'll say about SiteImprove is that it has a specific ADA Title II compliance report that focuses specifically on WCAG 2.1 AA, and that specific report has been like the most important thing in all of this work because that number with our ADA Title II compliance level, everything that we do to get that number a little bit higher means the world. So we're trying to tackle all of those problems and get that number as high as we can. And we also, in 2025, spent more time determining who is leading the actual remediation efforts of these different services. Using SiteImprove, we can pretty much tell what the issues that need to be fixed are on all of our web content, but we don't maintain all of our web content. Different people in different departments are responsible for different things. So taking all of those reports on the work that needs to be done and getting those out to the right people was no small amount of labor. Uh, Setting up a group so that we can all get together and work through these backlogs of issues because we're all kind of doing the same thing. We're all adding alt text and fixing broken links, even though it's on different pages of different websites. So there is kind of a miniature community of practice there to be established. And if that's a possibility for you to do at your organization, I would highly recommend it. Many hands make light work. Now in 2026, we are mostly compliant. I say mostly because there's a lot of ongoing problems that I'll talk about in the second half of this slide. But the stuff that we're still working on is getting accessibility training to our library web content creators. So the people who make new pages or write blog posts, we're trying to create like the minimum viable amount of accessibility knowledge that you need to know in order to not make silly mistakes like having a link that says click here or something like that instead of saying what it goes to. Little things like that because we want our content to be accessible, but also we spent so much time trying to get that accessibility score number up so high that if people, make silly mistakes and drop that accessibility number down for us, it's just more work for us. So, um, we're also in the middle of a double repository migration. We have an Islandora 7 instance that has a digital library and an institutional repository in it, and we're splitting those out to go to two separate vendors, one for the DL and one for the IR. So that's about as much work as it sounds like, which is all of your time. The current repository system itself is accessible, but most of the assets in there probably aren't. Um, and due to the undue financial and administrative burden we mentioned earlier, and this is something we're attempting to document. We've got more than 150,000 objects in there. The possibility of us going through all of those and remediating all of them after the fact is it's just a non-starter. We can remediate, but we could possibly make accessible copies of a thing if someone requests it. But I think that's about as good as we can really do. And the bigger your repository is, the bigger a problem that's going to be. Let's see. Under the ongoing problems, some of the reasons that we are mostly compliant is that some of the issues are either false positives where it thinks that there's a problem, but it's not, or the issues themselves are subjective. For instance, Site does not like that the title of our search results page is search results. It says that that is not descriptive enough. People need more to understand what's on the page. Um, I disagree with that. I think that there's some context there. If you just launched a search and you go to a page called search results, I feel like you know exactly what you're looking at. I'm not really sure what else we could add that would uh, give you more context without being redundant. Um, I had mentioned the repository system being accessible, but the assets are probably not. That's because remediating archival content is really, really hard. I I have not found any magic script where you feed it a file and that file comes out perfectly accessible on the other side. I have been told that there's stuff like that using AI where you feed it into an AI tool and it's perfectly accessible now. The people who are telling me this are trying to sell me the AI product, so I am a bit skeptical of what they have to tell me because it's been my experience that AI can do a decent job with like 60 to 80% of the problems, but it's not going to fix everything, and there's a huge possibility that it's going to introduce issues. So I just really don't trust AI to do a full remediation job. Also, don't have the money to pay for an AI full remediation job and wouldn't have the human resources available to moderate the output of an AI-based full remediation job. So, I'm not saying it's something that will never happen. It's something that I'm kind of putting up on a shelf to revisit later. I'm sure as the technology improves, that will become more and more feasible, but right now I just don't see it. Um, but that is my personal opinion. In addition to not being a lawyer, I'm also not an AI expert. Um, Receiving inaccessible materials is also an ongoing problem. If we made everything in our repository accessible, but we continued to receive inaccessible materials, we'd just get right back to where we started, right? Um, as a cultural heritage institution, you are likely not creating a lot of these materials that you're putting online. Some of them you're making yourself, but a lot of them you're getting from other places or they're historical materials or something like that. And when that's the case, when you are not there when the material is created, then you don't have access to all of the uh, accessibility checking and tooling that's present in the application that created the digital material. Because it's just way easier for it to be born accessible than to be have accessibility forced on it later. Yeah. Um, once it's left its birth application, it's kind of hard to put the genie back in the bottle, and repositories receive content created elsewhere almost exclusively. So I'll be getting into strategies for mitigating this in a future slide because we're about to jump into the next section, which is ADA Title II tips. Uh, some of these are going to be redundant in the sense that I already started hinting at them earlier, but these are the slides where I really put down like all my thoughts on what you should be doing in these different cases. So, as I mentioned earlier, document your effort. Keep all the documentation you have related to your compliance work. Um, See, we're working really hard isn't necessarily an airtight legal defense, but it's something. It's certainly helpful to show a judge that you're not just completely ignoring accessibility, that it's something that you are putting effort and resources into, and that you have an arc. Uh, and if you get sued, you're going to be asked for your compliance documentation anyway. So you might as well just go ahead and put it all together uh, for any case. Um, when it comes to this compliance documentation, if you can demonstrate that you have at least monitored and analyzed the accessibility of your content, then that's like a solid foundation to show that you're doing the work. But it's even better if you can document actual steps you've taken towards remediation and progress made. If you can show you're not just aware of the problems, but you're slowly solving the problems, and that the problem that you're getting sued for is on the list of things to fix, you're going to be in better shape than someone who cannot demonstrate that case. Also, if there are reasons why certain things can't be fixed, document that as well. Whether it's, we don't have the money or the resources to remediate all this stuff in our repository, or if there is an accessibility issue in a theme for your website that you purchased, but you don't have access to actually getting in and fixing. Like fixing the accessibility issue would be actually outside of the domain of things that you are able to do. Uh, Having that documented somewhere is helpful. It's not as good as fixing the problem, but it's better than nothing. Also, you're going to find if you start doing remediation work on your website, I'm not saying that actually missing alt text on images is 80% of the work, but I will say that it feels like 80% of the work. It feels like adding alt text to images is just a groundhog day that you repeat over and over and over. And as someone who has done that over and over and over, I've kind of developed I don't know, a rule of thumb for it, an idea of what I think makes good alt text that I think is backed up by other best practices on the web. And it's to strike a balance between clarity and brevity. You don't want it to be too long, and the shorter it is, the easier it is for the screen reader to read it or for a human to read it. Uh, but it is most important that you capture what's important about an image. And you're not just describing what's happening in the image, you're also thinking about the context. If someone is using a screen reader to look at this web page that has this image in it, why is this image here? What is that image adding to the page? And whatever it's adding to the page, that needs to be part of the alt text. Like if someone is describing, what do you call it? If someone is describing a math equation and you have an image of that math equation. It's not just enough to say, this is an image of a math equation. You want to say, this is an image of the math equation that is referenced on page 34 or something like that. Um, and there has been a big boom in generative AI for alt text. And AI is really good at describing what is in the picture, but it's not so great at capturing the context. For instance, way earlier in this presentation on the second slide, you saw a picture of me. The default AI generated alt text was bald man with beard. And while that is true, I am a bald man with a beard. I don't know if having an image of a bald man with a beard is adequate context. Like, why did they put a picture of a bald man with a beard on this presentation slide? And the answer, the context, is that it is a portrait of the presenter or an image of the presenter. Um, it's telling you that this is relevant to the presentation because I'm describing myself and this is an image of me. However, if I have a screen reader and I'm just saying this is an image of the presenter, it doesn't actually tell me anything about the presenter. So the actual alt text that I went for that image was uh, an image of the presenter of this presentation, Brian J. Brown, bald man with beard in blue shirt. I feel like that probably tells someone all the stuff they need to know. maybe a little bit too much, but it's certainly not wordy. I think it's fine. And I think those are the points that you need to hit with alt text is capturing the descriptive elements, but also the contextual elements to help someone understand how the image makes the page stronger. Um, Leverage accessibility tools to measure your progress. As I said earlier, there's tons of free accessibility tools, and especially if you don't really know much about accessibility, I feel that using these accessibility tools is crucial to developing an understanding of what accessibility is. It's way easier for me to understand accessibility by looking at actual issues out in the wild on the web pages that I administer and maintain than it is for me to understand accessibility from made up examples, right? Uh, and when it comes to exploring pages and understanding their accessibility issues, I prefer these free browser plugins. They are cross-platform. It doesn't matter if you're using Safari or Edge or Chrome or Mozilla or whatever. I think that Google Lighthouse and Wave have plugins for all of those different browsers. Google Lighthouse is obviously made by Google, and it will give you an accessibility report for a page, tell you all the problems that it encountered. Hmm. It will also tell you a lot of interesting information about performance, like how fast the page loads, which is kind of at the edge of accessibility, bordering on usability. But I would also say that, people who have low internet speed where page load would take a really, really, really long time. That is kind of a contextual element that might hurt your ability to interact with a web page. So that is kind of accessibility adjacent, I guess. There's also this tool Wave from a group called Web Accessibility in Mind or WebAIM, and it will actually overlay accessibility info on an actual live page. And I found that that was really helpful for me in understanding like what accessibility problems actually look like, uh, you know, in a real web page. As I said earlier, my favorite paid accessibility tool is SiteImprove. If you have it, use it. If you don't have it, and you think your organization might buy it, it's a good one. If you don't have it though, there are so many online that I haven't tried, so I can't recommend them. But all the ones that I've found, all the ones that I've used, have been fine. They've been totally usable. So there's something out there for you. If you try tools and you just don't vibe with them, just try another one. There's so many that you don't need to force yourself to use a tool that you don't like or don't fit with. Uh, and even though screen readers and color blindness simulators are not accessibility checking tools, they are accessibility tools in the sense that you can use them to empathize with users that have those issues, and you can see what it's like to access your own content as your users. I find screen readers really hard to use. Certainly, people who use them every day are much better at them, but I've gotten to the point where I can at least navigate a page with a screen reader and listen to it at the warp speed that halfway to warp speed that real power users are able to do. And when it comes to color blindness, um, it's interesting to see a filter on your pages that kind of mutes the colors so that I can tell the difference between red and green. But if I have a page that has red text on a green background for like, I don't know, a Christmas page or something like that, uh, someone who has color blindness is just going to see that as a big block of the same color. And you might never notice that if you're not using a color blindness simulator. You might not see what that looks like. Although most of these tools, if they're worth their salt, they're going to flag that as a contrast error that the text doesn't have adequate difference in colors from the text itself and its background. Uh, let's see. Creating workflows that are based on audit fix cycles. Give me just a second. All right. If you have any experience with project management, you've probably heard of waterfall style and agile style. Waterfall style is where you do all the planning up front, and then you work directly through all the stuff that needs to be done, and then you're done. And you hope that what you ended up with is what the client wanted. Maybe it is, maybe it isn't. Agile style of project management is more iterative, where you do little sprints on the backlog to take care of a chunk of related items. And then after a sprint is done, you analyze to see whether you really fixed those problems, and then you review the backlog, and then you take out another chunk of related items and you do another sprint. And you just keep sprinting and reviewing and sprinting and reviewing in a constant cycle until the backlog is empty. You have solved all the problems. I think that agile style of sprinting and reviewing is a lot more effective when it comes to accessibility testing and remediation, because how can you know if you really fixed the thing if you don't re-audit it? There is a phenomenon with accessibility checkers that I've noticed where, say you have two problems with a piece of content on a web page. The first problem might stop the accessibility checker from identifying the second problem. So you think you only have one problem, but when you fix the first problem, it's only then that you become aware of the second problem. So you need to get into the habit of re-reviewing to make sure that you actually fix the problem and that your fix didn't also introduce yet another accessibility error. So just don't think about it as one long block of work and then you're done. Think about it as a loop of checking and fixing until it's done. And I find that breaking it up into smaller groups like that also takes away a lot of the existential panic that you're faced with when you look at, 100 pages of stuff to fix. Um, And last but not least, I think this is last. Yeah. I had mentioned earlier about the ongoing issues, at least with FSU, of repositories getting data that is not accessible. So I'm calling this Pursue Upstream Accessibility. If you are getting stuff from elsewhere, try to try to create change in your organization or in your workflows so that the people who are giving you these documents are aware of the legal jeopardy that they are putting you both in if they are creating inaccessible stuff, and how it would be so much easier if they made it accessible at the time that they were creating it versus you having to enforce accessibility on it after the fact. Talk to them about their workflows, try to get accessibility checking involved in their workflows as much as possible. That way, whenever you get the stuff, it's not an issue. It's not tanking your accessibility score when you get it and you put it in your repository or on your website. Since archivists and repository administrators are constantly receiving stuff from other people, this means that those two types of people need to keep in mind the accessibility of digital materials when they accept them. And letting those people know that there could be lawsuits resulting in that, that's usually good enough in terms of like organizational motivator to affect some sort of policy change. Nobody wants to get sued. Uh, And then finally, as I mentioned, we're trying to teach our web content creators about accessibility, like the minimum that you need to know in order to make a blog post. That's something that everyone needs to be doing. Because if you have a lot of content creators, but they don't know about accessibility, then you have a lot of people that are going to be creating new stuff that is constantly chipping away at your accessibility score. You're all one team that everybody should be working towards raising that accessibility score, and they can do that with the new content that they create. So try to make that as low friction as possible, whether that's like a wiki page or a YouTube video or just a link to a guide about how to write accessible blog posts, whatever it needs to be. Try to make sure that that is part of your organizational workflows for teaching people how to use the website, how to post new content. Just shove some accessibility training in there as well. And that brings me to the end of my presentation. So I'll be checking the chat for questions along with Kayla.
Thank you so much, Brian. Everyone help give show Brian some appreciation with a round of applause. That was very informative. I don't see any questions in the chat at the moment, but I do have some questions that I jotted down. Um, I did like, this is a comment, I did like your balance approach for writing alt text. It sounds very much like the advice that I give when I'm talking about writing good metadata descriptions for things in repositories. So I think a lot of people in this room are probably already really well trained to think about that balance. Um, one of the questions that I had, so I know you mentioned that things like PDFs don't necessarily need to be accessible, but what about like specific kinds of content like handwritten material or non-English language content? If that's stuff that we're uploading after this deadline or after this cutoff date, should we be concerned about providing transcripts for this type of content?
Yeah, I wouldn't say that it is my statement that PDFs don't need to be accessible. There's so much context there that some PDFs may excuse me, some PDFs may not need to be accessible if they are old and archival and everything. Some of them might not be able to be made accessible, especially if they are PDFs of images of handwritten text like you're talking about. Uh, Especially some of the awful handwriting that I've seen that is just defies any kind of attempt at OCR. Um, but that's an example of like the administrative and financial burden. If you're paying someone to manually transcribe this, or you're trying to get some people to look through it and transcribe it. But I think that's really the only way to make something like that accessible is to offer like an actual uh, ASCII text representation of what the words in that picture in that PDF are, if that makes
Mhm.
sense. So coming up with some sort of OCR process and a test to see what the quality of that OCR is, that will probably need to become a standard part of any digital library's workflow for assessing new stuff that's going in. And if you don't have a good enough transcript, it might need to wait until you do have one.
Okay. Um, so there's a question that was sent to me directly. One question we've had with Title II is with the exempt archive content, does this include protection to any future edits to metadata or a platform migration that might change the item? Not sure if that makes sense, but we haven't seen much clarity around the archive piece. Thanks. Great presentation.
Thank you. Um, yeah, I would say if you're confused about what is or isn't archival material or what is or isn't falling under the exceptions, join the club. It's incredibly murky. That's once again, I'm not a lawyer, so I can't tell you an exact point on whether that stuff is or isn't covered. But I would say that it does at least make it pretty clear that you can't update the document. I wouldn't say that updating the metadata about the document is necessarily changing the document itself, but that is just my opinion. The way that I look at it is, even though I'm not an archivist, I'm thinking about it in terms of like the original archival item. Some of these like AI accessibility fixers that I've seen will maybe take an image and like resize it or spin it around or something like that, or add a caption to an image. And while all that stuff is cool, that is also fundamentally changing the original archival item. So I think those would be examples of things where even though you're making it more accessible, you are also changing the document itself. It's no longer like the historical record that it was. You know what I mean? Um, so sorry I don't have a more clear answer on that, but yeah, I'm in the same position of not really knowing what it means, you know?
I feel like a platform migration isn't enough of a change to constitute like uh
Hmm.
because if you're just migrating, this is my opinion. Again, I'm also not a lawyer, but the way that I'm interpreting that is if you're just migrating the content as is, you haven't changed it. I don't know that you're really updating it. You're just moving it to a different place.
Yeah, I'm thinking of the content. Like if we're talking about a repository example, the content is the PDF. The web page that displays the thumbnail of the PDF and maybe facilitates access to you downloading that PDF and displaying the context of the PDF, like what collection it's in and all of its metadata and stuff like that. Those are things about the system, not about the content. So even though the system around it might change, moving that individual PDF into a new system is not changing the document itself. So I think it's still archival.
So with things that are maybe like IP restricted or um, like licensed or things like that, that wouldn't fall under this because it's behind a password, right? Or it's restricted in a way.
Yes, yeah, technically anything that requires a password is accepted under ADA Title II. But once again, that's kind of murky because there's plenty of content that we have in the repository that you need a password in order to look at it. But that password is something that is open to all FSU students. So it's not public in the actual definition that ADA Title II puts forward, but morally, it's public to our students. You know
Yeah,
what I
to the
mean?
community that you're serving.
Exactly.
Yeah.
So I feel like IP embargoes and stuff like that, like you should still try to make the stuff behind that accessible, but if you choose not to, you've at least got a little bit more legal evidence to hide behind. I guess. Whenever I talk about the exceptions and documenting defensively and stuff like that, I'm kind of of two minds about it because on one hand, it makes it sound like I'm trying to tell you the secret to doing the least amount of effort to not have to do any accessibility for your website. And that's not what I'm trying to say. I do want your website to be as accessible as possible because accessibility is inherently good. However, we are all under a crazy time crunch to get all this stuff done. So it's not a matter of do I make it accessible or not? It's what do I need to focus on right now? What are the bigger priorities? And things that are IP restricted, being less public, are inherently lower priority,
Mhm.
in my non-lawyer opinion.
Right. And as information professionals, we're striving to make as much information available as possible. So hiding things behind logins is also not what we're advocating.
Yes.
Um, So yeah, that's all good information. And it's similar to the advice that I give in my copyright webinars about documenting your due diligence, in trying to do your research and the doing the work to make sure that we're providing the best access we can.
Absolutely.
I don't see any additional questions, but if anyone thinks of anything later, um, you can feel free to email me and I can pass that question on to Brian or send you some resources. Um, we are planning a follow-up to this webinar that myself and Jennifer Nicholson, who is also here from the State Library, are going to be presenting in April, just to give you some additional examples around social media and other things that are not necessarily repository specific or cultural heritage website specific, but more general. So keep your eyes open for that follow-up webinar. And thank you all for your time and attention today. And let's all thank Brian again for his time and expertise.
And thank you all for coming and caring about accessibility.